So you just got the email. You've been accepted into your dream Canadian university. That is absolutely awesome, and you should definitely celebrate. But I've got to hit you with a bit of a harsh reality check. That acceptance letter, it doesn't actually mean you're going to Canada. Welcome to this explainer where we're going to cut right through the noise and look strictly at the federal laws that actually dictate who gets to cross that border and who gets turned away.
It's a pretty tough pill to swallow, I know. A lot of folks think an acceptance letter is the finish line. You get that congratulations email, you literally start packing your bags. But legally speaking, the Canadian government hasn't even let you in the door yet. Academic merit simply does not equal immigration status. Here is exactly what we'll be covering today. Number 1, why study acceptance doesn't guarantee a visa. 2, your first prerequisite, a valid acceptance letter. 3, the main hurdle of proving your financials. 4, the critical difference between a study permit and a visa. And 5, the severe consequences of withholding facts. Okay, let's dive straight into Section 1 and shatter the most common illusion out there, the idea that a study acceptance guarantees a visa. See, universities and the government are looking at two completely different things. Universities have their own independent standards. They're looking at your GPA, your language test scores, your motivation letter. But the federal government, they operate under entirely different strict legal frameworks. Under Section 11 of the Immigration and Refugee Protection Act and Article 9(1) of its regulations, you are legally obligated to get an official study permit before entering Canada. The government doesn't care about your admissions essay. They care about security, strict financial proof, and your true intent as a temporary resident. Actually, think of it like this. Your university acceptance is just a concert ticket. Yeah, it shows you bought a seat. But the study permit? That's the strict security check at the venue door. The bouncer literally doesn't care about your ticket if you fail the security screening, right? You still have to pass those rigorous federal checks to actually get inside the venue. Moving on to Section 2, let's look at your first actual prerequisite, getting that valid acceptance letter. Before a federal officer will even glance at your application, there are absolute mandatory prerequisites you have to meet under Sections 216 and 219 of the Immigration Regulations. First, you need a valid passport. Then, and this is specifically mandated under Section 216E, you need an official letter of acceptance, an LOA, from a designated learning institution, or DLI. You also have to fulfill identity checks, give your biometrics, and pass health screenings. Without these core puzzle pieces, your application is literally a non-starter. Now for Section 3, the main hurdle. This is the big one, guys. The trapdoor where a staggering number of applicants fail, proving financial resources. So a very natural question comes up. If the government just wants to know you have money, isn't a massive sudden deposit in your bank account enough? A lot of people think, hey, I'll just borrow some cash from my uncle for a week, print the bank statement, and boom, I'm good. Well, legally speaking, that is a terrible idea. It's actually one of the fastest ways to get your application thrown right in the trash. There's actually a really famous federal court case from 2006, Lee v. Canada, that firmly established this. A sudden lump sum of cash is a massive red flag. In this case, the court upheld an officer's refusal simply because the applicant didn't document where the money actually came from. It is absolutely within an officer's jurisdiction to demand the source of your funds. You can't just suddenly have the money. You have to transparently prove its historical source. And that brings us to a really crucial legal concept, the burden of proof. In immigration law, the burden of proof means the responsibility sits entirely on your shoulders. You have to convince the officer that your financial history is legit. The visa officer, they aren't a detective. It's not their job to piece together your messy financial puzzle. If your documents are confusing or leave any room for doubt, the officer has every legal right to just stamp refused on your application. So, what does this mean for you? Your financial dossier has to tell a totally transparent, verifiable story. Under Section 220 of the regulations, yes, you must prove you have enough funds for tuition, living expenses, and a ticket home. But you also need to show a clear history of how that money accumulated over time. You need the exact verifiable source, and you must prove you have legal, unhindered access to it. You have to leave absolutely zero room for doubt. All right, Section 4. Let's talk travel logistics because there is a very important legal difference between a study permit and a visa. This specific distinction trips up thousands of students every single year. Look, a study permit is an internal status document. It authorizes you to study and stay inside Canada once you're there. but it is not a travel document. To actually board a plane and cross the Canadian border, you need an entry document. That means a temporary resident visa, a TRV, or an electronic travel authorization, an ETA. You cannot board a flight with just a study permit approval letter. No way. You need that entry document.
Finally, we reach Section 5, and we really need to talk about the severe legal consequences of withholding facts from your application.
Under Section 16(1) of the Immigration and Refugee Protection Act, there is something called a strict duty of candor. The law point-blank states that you must answer all questions truthfully and produce all relevant evidence. Failing to disclose something important isn't just an oops, my bad moment. It is treated as a very serious violation of federal law. So what exactly counts as misrepresentation? Well, it's things like hiding previous visa rejections. And yes, that includes rejections from other countries like the US or the UK. They all share information. It also includes presenting sudden unexplained money as your own. Or, as upheld in a recent 2024 case, Lamb v. Canada, submitting fake or illegitimately obtained educational credentials. Federal officers have immense authority to investigate these things, and they will penalize you. And the penalty for this misrepresentation? A devastating, non-negotiable 5-year ban from entering Canada. I cannot stress this enough. Taking shortcuts carries a massive legal burden. If an officer decides you misrepresented a material fact, you are deemed inadmissible to Canada for 5 full years. That means no study permits, no visitor visas, no PR applications, nothing. It will literally ruin your migration path for half a decade. Honesty isn't just a good idea here, it is an absolute legal requirement.
So the legal path to studying in Canada is paved with some pretty strict prerequisites. You need that valid DLI acceptance, a flawless and verifiable financial history, the correct entry documents, and absolute 100% honesty. Before you hit submit on your application, I want you to ask yourself, does your file tell the complete, verifiable truth, or are you just hoping the officer won't look too closely? Thanks for joining me on this explainer. Protect your future, know the law, and make sure your application clears the high bar it demands. Catch you next time.